Donald Trump has been found liable for sexual assault and defamation, and as a result, E. Jean Carroll has been awarded $5 million in damages. Now note that no one here has been convicted. This was a civil suit, not a criminal suit, so no one's guilty of anything, but Donald Trump is liable for $5 million. So today we're gonna talk about how we got here and what happened at the E. Jean Carroll trial. Now, E. Jean Carroll says that Donald Trump sexually assaulted her in 1995 or 1996 at the Bergdorf Goodman department store in Manhattan. At the time, Carroll was a TV talk show personality who also wrote an advice column. Carroll and Trump may have been acquainted with each other. The photo in the complaint shows the two of them together at a party during the same era. However, Trump denies knowing who Carroll was despite the photo. Now, Carroll said she ran into Trump when he was shopping for a gift for an unnamed girl. According to the Carroll complaint, she helped him shop, showing him handbags and hats. Trump rejected those ideas and steered Carroll upstairs to the lingerie section, where he allegedly grabbed a bodysuit and asked Carroll to try it on. She says that she told him to try it on himself, and Carroll claims that Trump pushed her into a dressing room, forced her up against a dressing room wall, pinned her in place with his shoulder, and raped her. After the incident, Carroll claims that she immediately called a friend and relayed what happened to her, and also claims that a few days later she confided in a second friend. Apparently fearing for her reputation and her career, Carroll decided not to report the rape to police. She believed that if she publicly accused Trump of rape, he wouldn't face serious consequences, while her life would be put on trial. Fast forward to 2016, when Trump was elected president, Carroll, quote, watched as a throng of women came forward and accused Trump of sexual assault, only to be denigrated and then brushed aside. Carroll says that seeing Harvey Weinstein finally face the music for the history of assault convinced her to go public. Carroll decided to write a book about her experiences with men, including Trump, entitled What Do We Need Men For? A Modest Proposal, which was published in July of 2019. Now, obviously, Trump has publicly denied assaulting Carroll in 3 separate statements, saying he'd never met Carroll, she was ugly, and she was not his type. He also asserted that she had no witnesses, and in response to Trump's statements, 2 of Carroll's friends came forward to corroborate her assertion that she told them about the rape shortly after it happened. Now, harassment and abuse are real problems that can happen to anyone. And now, my law firm, the Eagle team, can help if you've been the victim of sexual harassment or abuse in the past. And it's not just that. We can help with almost any injury of any kind. An auto accident, medical malpractice, workers' compensation. The link to our page is down in the description. We're here to listen and help. Now, in November 2019, Carroll sued Trump for defamation in his personal capacity in New York State court. Trump was still the president, and he defended the case on the basis that he had absolute immunity from civil lawsuits as such. Now, the scope of presidential immunity has only been tested a handful of times. In the 1982 case, Nixon versus Fitzgerald, the Supreme Court ruled that the president has broad immunity from lawsuits for official acts undertaken while as president. 15 years later, in Clinton versus Jones, the Supreme Court held that the president does not have absolute immunity from civil litigation surrounding acts that were not part of his official duties. Now, Trump's Justice Department, and eventually Joe Biden's Justice Department, intervened in the case to defend Trump, arguing that unlike Bill Clinton, Trump had immunity because the comments he made about Carroll were made in his personal capacity as president. So why would the 2 cases be treated differently? Well, Paula Jones's lawsuit against Clinton was for sexual harassment that happened before he was president, whereas Carroll's lawsuit is about statements Trump made while he was the sitting president, even though the acts themselves might have happened earlier. Now, it would have been so easy for Trump to escape liability in the Carroll matter if he had just stopped talking about her after he had become a private citizen. But alas, stop talking is not an instruction that Trump will ever follow, as dozens of lawyers can attest. And so in October of 2022, Trump went on Truth Social to rant and rave about Carroll. In his extremely long statement, he said, quote, "This Miss Bergdorf Goodman case is a complete con job. I don't know this woman, have no idea who she is, other than it seems she got a picture of me many years ago with her husband, shaking my hand on a reception line in a celebrity charity event. She has no idea what day, what week, what month, what year, or what decade this so-called event supposedly took place. The reason she doesn't know is because it never happened, and she doesn't want to get caught up with details or facts that can be proven wrong." Now, Trump's Truth Social statement was covered by hundreds of newspapers and exhaustively enumerated in this footnote, which is more like a yard note, am I right? Yeah, we'll try and find humor wherever we can here. But congratulations, Mr. President. You just bought yourself another defamation lawsuit because you re-upped the same comments after you were president. As a result, Carroll sued him for common law defamation based on allegedly false and defamatory statements he made on October 12th, 2022. She also sued him for common law battery. And on April 25th, a jury was selected and the trial kicked off. So what happened during this trial? Well, Carroll gave testimony about what she says happened. Trump's deposition was also played in court, although he did not attend. And a significant part of the trial has been 3 women explaining why they didn't call the police on the then real estate mogul Donald Trump. Carroll said she didn't go to the police because women of her generation were trained to be silent if a man attacked them. Trump's lawyer countered that Carroll once called the police on a group of children who attacked her mailbox on Halloween, suggesting that she would have called the cops on Trump if it had really happened. Carroll's friend, Lisa Birnbach, backed up Carroll's assertion that she did call Birnbach right after the alleged attack. And Birnbach said that Carroll was emotional and hyperventilating on the call. And next up was Jessica Leeds, whose first encounter with Trump was when he allegedly assaulted her. Per the complaint, Trump attacked Leeds on a plane when she was bumped to a first-class seat next to him. Leeds testified that, quote, there was no conversation, it was like out of the blue, it was like a tussle, he was trying to kiss me, trying to pull me towards him, he was grabbing my breasts, it was like he had 40 zillion hands. Natasha Stoynoff, a former journalist for People magazine, broke into tears when she was shown the Access Hollywood tape. She said that she was stunned and speechless when Trump attacked her, which happened when she went to Mar-a-Lago to interview Trump. Stoynoff says that she didn't report what had happened because she was afraid it would hurt her career. The jury also heard from Robert Salerno, an ex-Bergdorf Goodman executive, who testified that he didn't think that there were security cameras on the 6th floor during the 1990s. When Trump's lawyers questioned whether the dressing room doors would have been unlocked, Salerno said a lot of the time the doors were not locked, they kept them open or they propped them open. Now we'll get to Trump's defense or lack thereof in just a second, but there were so many interesting legal issues here that had a huge effect on trial. Before the trial, there was a question of the admissibility of the Access Hollywood tape. Trump's lawyer, Elena Haba, argued that the conduct Trump described in the video isn't at all like the violent rape that Carroll described. And in the judge's order analyzing this type of propensity evidence, he stressed that there are various ways that a reasonable person could interpret Trump's Access Hollywood statements. They could assume he's just a braggart making up stories, or that he was talking about what other stars did to women. Alternatively, a person could believe that Trump grabs women by the you-know-what, whether they consent or not.
Well, historically, that's true with stars.
It's true with stars that they can grab women by the
Well, if you look over the last million years, I guess that's been largely true. Not always, but largely true. Unfortunately or fortunately.
And you consider yourself to be a star?
I think you can say that, yeah.
Now, ultimately, Judge Kaplan ruled that the jurors could reasonably conclude based on the tape alone that Trump, quote, in fact has had contact with women's genitalia in the past without their consent, or that he has attempted to do so. So this meant that the jury would hear the Access Hollywood tape in trial and would decide for themselves whether it indicated that Trump routinely touches women in their intimate areas with or without their consent. Now, Donald Trump made the unusual decision not to put on a defense. The only 2 witnesses on Trump's witness list were Trump himself and a psychiatrist, but neither testified in court. Now, that doesn't mean he was conceding liability. His lawyers cross-examined all the plaintiff's witnesses, and the plaintiff, Eugene Carroll, has the burden of proof in this case. Though, as we'll talk about, the burden of proof in a civil case is very, very different from the burden of proof in a criminal case. Trump's lawyer, Joe Chacapina, questioned why Carroll didn't scream. She said, quote, I'm telling you, he raped me whether I screamed or not. I don't need an excuse for not screaming. And Stoynoff testified that she also didn't scream. And in addition to asserting that the assault never happened, Chacapina argued that the lawsuit was part of a vast conspiracy against Trump. And Judge Kaplan allowed the defense to question Carroll on why she decided to file a lawsuit, eliciting testimony that she got the idea to sue from never Trump lawyer George Conway, Kellyanne's former better half. And Conway introduced Carroll to her now lawyer, Robbie Kaplan. And Chacapina tried to find inconsistencies in Carroll's statements. Chacapina offered an audio clip of an interview where Carroll said that she didn't blame Trump for her failure to have another relationship. Quote, I think it wasn't because of him. I think it was, I just didn't have the luck to meet the person that would cause me to be desirous again. I think maybe in that dressing room, my desire for desire was killed. Carroll also admitted that she was a massive fan of The Apprentice, which might have been at odds with her assertion that the alleged assault damaged her. Chacapina showed a jury a 2012 Facebook post where Carroll jokes about whether she would have sex with Donald Trump for $17,000. And now, whether any of that actually amounts to an inconsistency is up for the jury to decide. But in a civil case like this, the plaintiff has the burden of of proof. But the burden of proof is not beyond reasonable doubt. It is a preponderance of the evidence, which is basically more likely than not, or 51% compared to 49%. It's only showing that your story is more believable than the other side's. So the burden is lower, but still the plaintiff does have the burden here. So Trump's lack of a defense is less strange than it might seem on its face. After all, his claim is that what E. Carroll is claiming is not true. And if he had the burden of proof, he'd be trying to prove a negative. He just simply needs to say that it's more likely that it's not true than it is true. Now, I also mentioned some propensity evidence, which is fairly unusual in a case like this. There were two women that testified that Trump assaulted them in the same way that he allegedly assaulted Carroll, Natasha Stoynoff, and Jessica Leeds. Now, there was a huge battle over the admissibility of this propensity evidence before trial even got underway. Now, propensity evidence is evidence of one crime that is used to show the defendant is more likely to have committed another crime. Now, there is generally a bar against using propensity evidence or character evidence to prove that a defendant committed a crime or a civil tort. Now, if someone committed a crime in the past, they are probably more likely to have committed the crime at issue, but the courts believe that it's too easy to draw the conclusion there and that you really need to prove a crime actually happened in this specific instance without being able to show that they just have a character for doing so. And in fact, Federal Rule of Evidence 404 states in part that, quote, evidence of a person's character trait or trait of character is not admissible for the purpose of proving action in conformity therewith on a particular occasion. Now, Rule 404 exists because juries tend to overvalue character evidence when we don't want to find a person guilty or liable just because they had committed a prior bad act. However, Federal Rule of Evidence 415 removes the character evidence bar for sexual assault cases, probably because it's a recognition of how hard it can be to prove a case in a he said, she said case. That rule states, quote, in a civil case involving a claim for relief based on a party's alleged sexual assault or child molestation, the court may admit evidence that the party committed any other sexual assault or child molestation. So how do we square Rule 404 with Rule 415? Well, when a victim comes forward with allegations of sexual assault, juries tend to minimize the victim's story unless there is evidence that a defendant did it to someone else. And Rule 415 is supposed to level the playing field for victims of sexual assault. Trump's lawyers filed a motion to exclude the Leeds and Stoynoff testimony on the basis that whatever it is that Trump did to them, it wouldn't qualify as sexual assault and therefore couldn't be admissible under Rule 415. But on March 15th, the judge ruled that if true, the allegations by both women would qualify as a type of sexual assault and their testimony would therefore be admissible. Trump then brought in Joe Tacopina as his trial lawyer. Tacopina has previously defended Michael Jackson, Alex Rodriguez, and Meek Mill. Tacopina filed a motion on the eve of trial attempting to relitigate the admissibility of Stoynoff's testimony. Now, judges hate relitigating the same thing that they've already ruled on, and this second argument went over like a lead balloon. Judge Kaplan denied the Tacopina motion, writing that the motion was not just untimely, but also that Tacopina failed to show that the court's original decision overlooked matters or controlling decisions. So what did Carroll have to prove in this case? Well, Judge Kaplan ruled that Carroll's defamation claim was for libel per se. All that meant is that in a defamation per se case, a plaintiff doesn't need to prove damages at the outset. They were initially presumed. And Carroll had to prove that Trump's statements were untrue and that they harmed her reputation and profession. We've covered this a lot on this channel. Carroll had to show that Trump's statements had a tendency to expose her to public hatred, contempt, ridicule, or disgrace. And she had to prove that when Trump denied knowing her and denied sexually abusing her, that he knew it was false or acted with reckless disregard for the truth or falsity of that statement. And in a way, Carroll's civil battery claim was easier to prove than defamation. Battery is the intentional, harmful contact of one person against another, and Carroll alleged that the potential crimes that gave rise to the battery included rape, sexual abuse, sexual misconduct, or forcible touching. Now, you might be wondering why a battery that is more than 25 years old was being heard in 2023. And the statute of limitations to bring civil lawsuits over sexual assault in New York is generally 3 years. And, the statutes of limitations exist for a good reason. After a sufficient amount of time has passed, it can be hard for a defendant to muster a defense because evidence just disappears over time and witnesses lose their memory. But here in 2022, New York passed the Adult Survivors Act, which opened a 1-year window from November 24th, 2022 to November 24th, 2023 for people to sue their alleged assailants, even if the statute of limitations had expired. And Carroll filed her lawsuit within minutes of the law taking effect on November 24th, 2022. Now, despite some dubious motion practice from Joe Tacopina, Trump's lawyer, he actually received some praise from the judge for his skill in the courtroom. courtroom. But unfortunately for him, he had Donald Trump as a client, and Trump boxed himself into a corner regarding his defense. By claiming that E. Carroll made everything up, it allowed the plaintiff to easily refute that particular defense. Trump claimed that he had never met Carroll and she wasn't his type, so the evidence that they had met, despite being tenuous, was bad for Trump. And the same with his deposition testimony that he confused her with his ex-wife Marla Maples. And the plaintiffs jumped on that, and the videotaped footage of Donald Trump's deposition was fairly devastating.
I don't even know who the woman, let's see, I don't know who, it's Marla.
You say Marla's in this photo?
That's Marla, yeah, that's my wife.
Which woman are you pointing to? No.
Here.
Carroll.
Oh, is that,
The person you just pointed to was E. Carroll.
Who is that? Who is this?
Point. You're right.
By the way, it was completely inappropriate for Trump's lawyer, Alina Habba, to jump into the deposition and coach the witness and suggest the right answer after Trump's fumble. Now, the legal maneuvering was continuing throughout trial. For example, Joe Tacopina told the judge that Trump was not going to testify. However, at the same time that Tacopina was resting the defense's case, Trump was telling a press gaggle in Ireland that he intended to cut his trip short to confront Carroll in court. He said, quote, "I was falsely accused by this woman. I have no idea who she is." Then Judge Kaplan did some legal maneuvering of his own and point blank asked Tacopina whether Trump was waiving his right to testify. Tacopina said yes. Then Judge Kaplan said, quote, "How recently have you spoken with him?" To which Tacopina replied, "A few minutes before I came into court this morning." Now, Judge Kaplan probably knew what was coming next, where Trump would claim he wasn't allowed to testify because the whole system was corrupt, especially the judge. So Judge Kaplan bent over backwards to make sure that he gave Trump every opportunity to be heard. So he told Tacopina that his client had until 5 p.m. on Sunday to file a motion to testify. But Trump, to no one's surprise, did not return to New York, and Tacopina did not file such a motion. And now we have the verdict. A federal jury in New York found former President Trump liable for defamation and assaulting Carroll in the 1990s. The jury awarded Carroll $5 million in compensatory and punitive damages after deliberating for less than 3 hours, which is not a lot of time for a jury deliberation. And when a jury is deliberating, the jurors review the instructions on how to apply the law and then answer questions on the verdict form, which we happen to have here. Here, the jury rejected the allegation that the encounter between Carroll and Trump constituted rape. You can see that the question was number 1 on the verdict form. The jurors instead checked the box on the verdict form, which was in the alternative of sexual abuse. That means that the jury believed Trump touched Carroll without her consent. So while the jury found that Carroll met her burden regarding sexual assault, they apparently did not find that she met her burden that Trump had penetrated her, which would have been required for the rape allegation. So the jury awarded her $2 million in compensatory damages for the abuse. Turning again to the verdict form, the jury concluded that Trump had made a false statement, and that he made this false statement with actual malice, which was a high bar for Carroll to clear. The jury awarded her $1 million in damages for compensatory damages for the amount that she actually lost effectively out of pocket, and an additional $1.7 million for damaging her reputation. The jury added $280,000 in punitive damages and an extra $20,000 for wanton disregard. And in concluding, Judge Kaplan advised the jurors to keep their identities secret and not to publicly identify the other jurors. And although it's legal for jurors to talk about their experiences and identify themselves to the media, here the judge had taken extraordinary precautions for a civil case, ruling that before trial the jury would be anonymous due to the threats that Trump and his supporters have made against juries and prosecutors in the past. But now that Carroll was successful, she'll probably want to celebrate with a delicious home-cooked meal, which she can do with today's sponsor, HelloFresh. She doesn't even need to spend $5 million on it, because HelloFresh is a great way to eat delicious fresh food while still being healthy. It's a great way to get back into a diet or just eat great food. In fact, HelloFresh has a whole variety of calorie-smart, carb-smart, pescatarian, and veggie options, and you can customize it how you want to. HelloFresh delivers fresh, quality produce from the farm to your door in less than a week, and this May, HelloFresh is celebrating Asian American and Pacific Islander Heritage Month, so you can try limited-time authentic recipes created in partnership with Chef Surbi Sani of New York City's Tagmo restaurant and enjoy a cultural taste tour right in your own kitchen. Now, I'm a do-it-yourself person, and I have to say I was initially pretty skeptical about HelloFresh because I think I'm a pretty good cook and I didn't really need the help, but I actually loved it. Even for an experienced cook, HelloFresh delivers new ingredients and recipes that I'd never try on my own. And of course, everything was delivered straight to my door, so I didn't have to do any shopping. The produce actually gets to you faster than a grocery store, so it arrives at peak freshness and flavor, and it's also super easy to save time. HelloFresh cuts out meal planning and prep, so the recipes only take 20 to 30 minutes to cook, which is literally less time to cook than it would normally take to do shopping. And HelloFresh is actually cheaper than grocery shopping and at least 25% cheaper than takeout. So if you'd like to try HelloFresh, go to HelloFresh.com and use the code LegalEagle16 for 16 16 free meals plus free shipping. Yes, you can actually get 16 free meals plus free shipping by clicking on the link that's on screen right now or down in the description. So click on the link below and use the code LegalEagle16. And after that, click on this playlist over here for more Legal Eagle, or I'll see you in court.